Good evening, ladies and gentlemen. Suzanne Dibble here, data protection law expert, coming to you live in Uncut on a Sunday evening. And I'm going to talk to you today, after requests in the group that I do this, I'm going to be talking to you about GDPR and children. So the areas that I'm going to cover on this video, because there are more issues to consider, but I'm going to focus on just 3 on this video, are the sort of general approach to processing children's data, marketing to children, and what we need to do in privacy notices if we are processing children's data. So if that applies to you, then listen on. Okay, so what's changed with processing children's data? Well, it's not fundamentally changed actually to the rights that they already have under existing data protection legislation. But what GDPR does say is that it explicitly states that children's personal data merits specific protection. Which you kind of expect, wouldn't you? You know, children, they're, less capable of assessing the risks. They're more likely to not think through all the consequences. So it's kind of obvious to me that you would put a higher level of protection in there for children. So new requirements are that in circumstances where an ISS, which stands for Information Society Service, which is essentially things like, it's online services really. So it could be, and actually it also applies even if it's not a paid for service. So for example, a free gaming app or a search engine, obviously search engine provided for free, and they're funded via advertising, then they still come within the definition of an ISS and an online service. And there are new rules around providing an ISS or an online service to children. So I think I'm going to do a separate video about that because that is quite a complex area. So if you are offering online services to children, directly to children, then I'm going to do a separate video on that. Okay, because that's a new area. In a similar way to adults, children have the right to not be subject to decisions based solely on automated processing, including profiling, if they have a legal or similarly significant effect on them. And finally, and this is what I will be talking about later, GDPR requires the provision of age-appropriate privacy notices for children. So if you are marketing to children, or there's even a chance that children are using your services, then you need to think about a privacy notice for children. And I'll talk about that in a bit. Okay, so the general approach to processing children's data, and I'm going to quote from recital 38 of GDPR, which states, children require specific protection with regard to their personal data, as they may be less aware of the risks, consequences and safeguards concerned and their rights in relation to the processing of personal data. Such specific protection should, in particular, apply to the use of personal data of children for the purposes of marketing or creating personality or user profiles, and the collection of personal data with regard to children when using services offered directly to a child. The consent of the holder of parental responsibility should not be necessary in the context of preventive or counselling services offered directly to a child. And I'll say more about that when I talk about online services being offered directly to children. So you may have heard of this concept of data protection by design and by default. And the design part of that means that when you are right at the outset, when you're designing, you're processing your products and your systems, that you should have that protection in mind. And the ICO comment that this is vital if you regularly or systematically process children's personal data. It's usually easier to incorporate child-friendly design into a system or product as part of the initial design rather than try to add it in later. And the best practice here is to use a data protection impact assessment, and that is a document that is in my GDPR pack, to help you assess and mitigate the risks to children. And an example of that the ICO give is that when you're building your, app or your whatever it is, then to protect children from unwittingly sharing data that they don't think they're going to be sharing, then you would set the privacy settings on the app to not share. You would set the default privacy settings would be set to a very high standard. And when the children are able to activate any kind of sharing mode, then you would include a very clear child-friendly explanation of the increased risks of sharing those details. Okay, so you've got to think about data protection by design for children and building those protections in from the outset. Now, you might say, okay, well, I'm not sure if my data subjects are children or not. What do I do in that case? And obviously, that's an issue if you are, online or doing some kind of remote processing. And the guidance here is that if you aren't sure whether they're children or not, you usually need to adopt a cautious approach. And what that might mean is designing processing so that it provides sufficient protection for children, even if you're not absolutely sure that children are using it, putting in place proportionate measures to prevent or deter children from providing their personal data, taking appropriate actions to enforce any age restrictions you've set, or implementing upfront age verification systems. And the guidance says that the choice of solutions may vary depending upon the risks of the processing, the rights and freedoms of the child, and the particular provisions of GDPR that apply to your processing. So there is a note, I can't remember where I read it now, but it did say that the ICO at the moment accepts that that there needs to be a technology solution to this. It talks about putting in place proportionate measures to prevent or deter children from providing their personal data. What are those measures? Because if you say to a 13-year-old, tick here to confirm that you're over 16 or whatever, or over 18 or whatever, then that 13-year-old, there's a high chance that he's going to tick it anyway, isn't there? So what is that technical solution that is going to deter children from providing their personal data? In that instance, I don't know. If you do know, if you've read it somewhere, then do post it in the comments to this video. It's also good practice to consult with children. So this is still talking about the general approach to processing children's personal data and this concept of data protection by design. And it is, if you're deciding to implement a new processing or a new product or a new service, then it's good practice to consult with children about the processing, about how it all works, the privacy, that type of thing, and that'll help you identify the risks, design safeguards, and also importantly assess the understanding of the different age ranges of the children, so that you can create solutions that mitigate those risks and give the appropriate safeguards for the relevant ages. So it's a lot to think about, isn't it? If you're processing children's data, for the sort of general small business owner or sole trader or micro business, that's quite a lot to think about. But I think it's important that we do. I mean, I don't sell to children. I don't process children's data. But I think if I was and I was a very small business, I'd be thinking, crikey, how am I going to manage all this? So do remember that it's all about the weighing up the risks to the child. So what these regulations are really designed to catch are the things like the Snapchats and the apps that the kids are using, and where it is easier for children to share personal data that they might not be aware that they're sharing, or that they're just not conscious of, that it's not a great idea to share that level of data. I think, you know, they're the online services that the regulations are out to catch. Saying that, don't ignore it. You know, if you are, you know, at least, you know, sort of regularly and systematically processing children's personal data, do carry out a data protection impact assessment and have it on record. So even if you come to the conclusion that you're doing everything you need to, then, you know, have it on record, because so much of the feedback that I've had from the ICO is that what they're interested in is that internal accountability, and you having actually done that thought process and actually thought about the risks to the child and thought, okay, well, that's a risk. How can we mitigate that risk? Here's what we'll do. So remember that it's all proportionate. So if you're a small business, they're not going to expect you to go and implement, you know, well, it's proportionate. So if you're a small business and the risks are low of you know, any impact to the rights and freedoms of children, and it having a negative impact on them, then it's proportionate. You know, so you're not going to have to go out and spend a vast fortune on some technology solution to protect the children. So please, you know, don't be unduly concerned by this. I think, yes, you have to be sensible about it, and if you are processing children's data, then you need to at least have that thought process. Get my data protection impact assessment from the pack, and actually carry out that exercise. And remember that a lot of the things I said there were just good practice. So the things like consulting with children is good practice, for example. Okay, so that is the general approach to processing children's data. The next thing that I want to talk about is, shall I talk about consent? No, I'm gonna leave consent, I think, until the next video. I think I'll do that in the context of online services for children. Okay, so the next thing that I want to talk about is marketing to children. Let me just find my notes on that. Oh, right, here we go. So, marketing to children. So GDPR states specifically that children's personal data merit specific protection, which should in particular apply to the use of their data for marketing purposes or creating personality or user profiles. But here I'm focusing on the marketing. Okay, so the processing of children's personal data for marketing purposes merits specific protection. Now, that doesn't mean that you're prevented from using children's personal data for marketing purposes, but you need to be additionally sure that you're meeting all of the requirements of GDPR. And as part of that, you need to explain what you're doing with their personal data to the children in a way that they can understand. And I'm going to talk about that a little bit more in a bit, about specifically how a privacy notice would change for being transparent in terms of what you're doing with children's data. In all circumstances, you need to ensure the child is specifically protected when their personal data is processed for the purposes of marketing, and you should not exploit any lack of understanding or vulnerability. I hope it goes without saying that nobody in this group would actually do that. Now, there's also the Advertising Standards Authority Code on not using children's personal data in a way that might lead to their exploitation, and I'll post a link to that in the group. Okay, I think that's all I want to say about that. Okay, so that leads neatly on to how you need to put together a privacy policy for children. Now, I'm anticipating the groans already if you do actually process children's data, because the privacy policy, so you have to provide the same information that you provide to adults, and that is laid out in the privacy policy that I have in my GDPR pack. However, you need to write it in a concise, clear and plain style. And this is the important bit. It should be age appropriate and presented in a way that appeals to a young audience. Okay, it's good practice to provide separate privacy notices aimed at both the child and the responsible adult if you're relying on parental consent as your lawful basis for processing. I'll say more about that on my other video, but in summary, the GDPR gives member states the right to set their own age limit for consent for online services, and the UK at the moment, it's not been passed, it's going through Parliament, but at the moment it looks like the UK's or England's age limit will be 13. Okay, so good practice if you're getting parental consent because you're targeting children that are younger than 13, then it's good practice to provide separate privacy notices aimed at both the child and the responsible adult. Now, more than that, I'm going to hear even more groans coming here. The ICO guidance actually then goes on to say you should make a distinction between addressing, for example, a 10-year-old and addressing a 16-year-old child. If your target audience covers a wide age range, consider providing different versions of your notice. So you've got your, in theory, you've got your adult notice, you've got your 16-year-old notice, you've got your 10-year-old notice, and who knows what else. You've also got to present the privacy notice in a way that's appealing to a young audience. So, i.e., not the one in my GDPR pack, which is just plain text. The ICO advise us to consider using diagrams, cartoons, graphics, and videos that will attract and interest them. And if it's in an online privacy policy, then consider the use of dashboards, layers, just-in-time notices, icons, and symbols. So that is quite a, for the small business owner, for the micro business, for the solopreneur, that is probably something that you're sitting there thinking, how am I going to have the time and resources and money to implement that? And again, it is this risk assessment. If you are, if you have things that are targeted at children, where there are risks inherent in the processing of your data that could have a significant effect on the rights and freedoms of those children, then I'm afraid you probably do need to invest that time and money in putting into place those child-friendly privacy notices that, with the all singing, all dancing videos, etc., and the different age-appropriate ones. That's something that you're just going to have to take on the chin. If, however, you process children's data, but there aren't those risks, then you just have. I think it would still be good practice if you are targeting children and targeting children under 13. It would be good to have one for the child and for the parent. But it is all proportionate. So you do have to go one step further than those who don't process children's data. But hopefully, if the risks are low, then the exercise shouldn't be too onerous. Right, what else? Okay, there are a few other things that particularly apply to children, but I think I'll save that for another video. So just to sum up, children need particular protection when you're processing their personal data because they may be less aware of the risks involved, which we can understand. Think about the need to protect them from the outset when you're actually designing your systems and your processes, and think about those risks and how you can mitigate them. If you rely on consent as your lawful basis for processing personal data and you're offering an online service directly to a child, then only children aged 13 or over are able to provide their own consent. And again, I'll say that's just going through Parliament at the moment, but I'm sure it will be more than likely approved at 13. So that's the relevant age. For children under that age, you need to get consent from whoever holds parental responsibility for the child, unless the online service you offer is preventative or counselling services. I'm going to say more about that on a separate video. Write clear privacy notices, age-appropriate privacy notices for children. If you're regularly and systematically processing children's data, then use data protection impact assessments to help assess and mitigate the risk to children. And if your processing is likely to result in a high risk to the rights and freedoms of children, then always do carry out a data protection impact assessment. Now, actually, I did read somewhere, I've lost that bit because I found it very interesting, because it was the point about the fact that in the UK, under English law, the age limit will be 13, and if you've got, say, we set the age of 13, France sets the age of 15, somewhere else sets a different age, then I did read somewhere that you would have to have a way of detecting which country they're from and varying those age limits appropriately. So if you could tell that they're from France and their age limit is 15, then you'd have to have a system in place that obtained parental consent for anybody under that age. So that's a whole different level of complexity. I'm just saying that while I remember it, because otherwise I might forget, because that's not in my notes. But I did read that and thought, crikey, that's a fair obstacle to surmount, isn't it, with the technology solution to that. But I'll talk more about that when I talk about online services to children. Okay, so I think that's a bit rambly tonight. Brain's not quite as much in gear as it normally is, but I hope that's helpful for those of you who have asked about children. I say, remember, it's all about, it's proportionate, assess the risks. Yes, if you're processing children's data, but it's fairly low risk that the children are going to be impacted in any way, then, the basics apply in terms of certainly having a child-friendly privacy policy, albeit that it probably doesn't have to be an all singing, all dancing video, graphics, something like that for children, but certainly being a little bit creative about what's going to appeal to a child would be a good idea. So, questions, comments, let me know on the video, sorry, I can't even speak at this stage in the evening. Let me know in the comments below. If you deal with children, let me know your thoughts. Is this an area that you're concerned about, or are you, relieved that I have talked about proportionality and an assessment of the risks? That is it. If you've listened this far, well done. I'm going to be interviewing a security expert tomorrow. So if you're listening to this in a week's time, it will have happened, but do go and search for that interview if you want to know about what small businesses and online businesses can do to put in place appropriate security measures for protecting personal data. If you haven't yet bought your GDPR pack, then go grab it. The price is going up on the 29th of March. Well, it's actually going up on the 30th, so the 29th is the last day to buy it at the introductory price of £97. Now is the time to buy it. That's why we're doing the price rise, so that you actually take some action, and you've got 2 months to do your data inventory, work out where you're transferring data to in terms of third parties, look at whether they're compliant or not, put in place your privacy notice, look at processor agreements, etc. So now is the time to start looking at it. So go grab it before the 30th of, I think the 30th is Good Friday. So Thursday is the last working day of this coming week. So if you haven't yet got it, go and grab it. And if you're watching this video on a replay a week down the line and you haven't yet got it, then I'm afraid you've missed the boat. It'll still be available, but at a higher price. So I hope you do get the opportunity to grab it before that. Okay, I have rambled enough tonight. Tomorrow the short, sharp, succinct version will be resumed. But with that, thank you for watching as always. Thanks for spreading the word about the group. I'm just blown away. We had another, I think, 500 requests to join in just today on a Sunday. totally random. But anyway, thank you for all your support, for being in the group, for engaging, for asking brilliant questions, for sharing. I love you all.